Senior Counsel Ahmed Nasir. We urge the court not to take that direction, as it would be then turning that test not from an objective test, but subjective test, looked at from the perceptions as they are held by Senior Counsel Ahmed Nasir. Your Honor, my lords and my ladies, we ask you, please, do not fall into that folly that the applicants seek to drive you. My lord, lastly, I will discuss one of our cases with regards, and this is particularly with regards to the profession, as has been discussed by my seniors, that we are indeed a homogeneous group. We are all advocates, and this is particularly important when it comes to the allegations as against Justice Murima. In the case that we have placed before you of Perry versus Schwarzenegger, it runs from page in this case, the perception of bias is that Justice Murima is friends with His Excellency the Senator, who is a fellow learned friend. And the court said this: in a case that could affect the general public based on the circumstances or characteristics of various members of that public, the fact that a federal judge happens to share some of the circumstances and characteristics will only be affected in a similar manner because he is a member of the public. This is not a basis for disqualifying a judge. My Lord, having considered the law and the facts before you, it is readily apparent that this application has not risen up to call for your introspection with regards to your empanelment in this matter. That is all, my Lord. And my lady.
My Lord, allow me to just seek a procedural clarification that the right to reply is available only to the persons who, the advocates who filed the application, and not the parties who supported that application.
We made that clarification at the beginning.
Thank you.
Perhaps, my Lord, you could also confirm whether it is limited to matters of law.
I said that we made that clarification at the beginning of the proceedings.
My Lord, we could also perhaps confirm whether the reply is limited to legal issues, because if it's another bite at the cherry, we will not have the opportunity then to again come back to redo it.
May I say something, my Lord?
The reply will only be on issues of law and nothing else.
Thank you.
Dr. Kamino, you can say.
May I say what I wish to say, my Lord? My Lord, if I may quote words of Chief Justice Marshall, we are expounding on law on a matter relating impeachment. Impeachment for the first time before the Kenyan courts. I pray that you allow me to say something.
I said you can proceed.
Oh, thank you very much. Oh, thank you, Judge. And God bless you.
Thank you very kindly. I will do part of the reply, then I'll pass over to my senior. And I'm amazed at what level the respondents have gone to misconstrue and misconceive the applicant's case. Your Lordship, in respect to the relationship that were drawn, both for the presiding judge and Justice Murima, the charge is that of deliberate failure to disclose the relationship that your my lords, you are aware at the time of the inception of the case that Justice Mrima is closely associated to
parties.
May
You say clearly, if you can't understand what we are doing, please go to your affidavit and read the affidavit again.
My lord, I'll then
And reply on matters of law. I will not allow you to misrepresent facts. You have an affidavit.
And to embarrass the legal profession.
Yes,
Your Lordship, I
you
look
have an affidavit, Mr. Ndengwa. If you can't understand what we're talking about, verbatim, read verbatim from your affidavit.
Your Lordship, may I draw your attention to paragraph 74 of the judgment of the ruling in Navini. The judge says that due to the failure to so disclose on the part of the third respondent, it has led to an erosion of the confidence and the applicants have that will be neutral when it comes to the hearing and the determination of the arbitration. That, Your Lordship, is a confidence that has been eroded. On the question, Your Lordship, on the duty to sit, the duty to sit must be accompanied by transparency and accountability to the parties appearing before a judge. Your Lordship, the duty to sit and the oath of office taken by a judge or a judicial officer must be executed in a manner that breeds confidence to the parties that appears before a judicial officer. Lordship, it's our humble submissions that confidence has been eroded. Your Lordship, the arguments by Mr. Nyamondi that the parties are forum shopping. Your Lordship, this bench was constituted pursuant to Article 165, Clause 4 of the Constitution, and no petitioner herein has the capacity to direct the Chief Justice who constitute the bench as to which judge to sit in a particular bench. There is no possibility, Your Lordship, therefore, for an argument that parties are forum shopping. At the inception of the proceedings, Your Lordship, we appeared before you and made arguments comfortably. Little did we know that we would be faced with an application of this nature due to the failure of the honorable judges to disclose those material facts. I invite Kibe to proceed.
My Lords,